I think the important thing for journalists to consider in this modern era is that one, if they're in the process of collecting information for publication, whether you're a professional journalist in connection with a news organization that is established, that's recognized, or whether you're the so-called citizen journalist, the amateur journalist, if you will, if you're in the process of producing a publication of any kind, whether it's a traditional print publication, whether it's a broadcast of some kind, or whether it's something you're doing online, if that's a regular process that you're engaged in, you are protected by the same laws that affect all journalists. And that's the expanded area that I think is uncertain in some sectors, but certainly to the extent that you're producing information, you're considered a journalist. I know it's true under the Illinois Shield Law. If you're producing a regular publication, you're subject to the protection of the Shield laws. In other words, you can protect your sources of information. So those are the kinds of considerations that people need to keep in mind. It doesn't matter what you're saying. It doesn't matter whether people have attached relative value to it or not. You're in the process of issuing a publication, if you will, that is protected under the First Amendment. Everything else becomes complicated in comparison to issues of national security and the same principles that have applied since 1919 with respect to clear and present danger give authorities the right to sort of limit the First Amendment protections. And then the Patriot Act adds another really scary layer to all of that because of the ability to at least determine that there is some connection to somebody who is suspected of terrorist activity, and that's all they need to open the door to all kinds of inspections of your materials. So those are things to keep in mind. You are a journalist if you're in the process of producing information for consumption. It doesn't matter what the means are, if it's a newspaper, a magazine, broadcast, or online operation, you are protected. The issue is to determine what the scope of that protection is in this in this contemporary moment. As a journalist and as a lawyer, I care a lot about rights of expression. And as a writer, I certainly want to have the maximum freedom possible. As a lawyer with 15 years of media law practice, my job was always to screen copy to make sure that our reporters were not going to get called into question on issues of defamation, invasion of privacy, and that sort of thing that would cause us to have to surrender any documents to authorities. So the consistent link between these two areas is that I'm an advocate, and I'm an advocate for expression and our right to continue to do what we need to do in order to further the interests of the democratic society. We have shield laws in the states only. There is no federal shield law to protect sources of information that reporters might gather. So the steps that have to be taken generally are to make sure that you're talking to sources about information that is germane to a particular story. There are exceptions to shield laws, and if an authority is investigating a crime and the information that you have is indispensable to that investigation, then you may be called to produce that information. If it's marginal, then of course there are some arguments that can be made. What you generally have to do is to make sure that you're careful with respect to the information that you get and the nature of the information as it relates to the story you're working on. These days, the challenge is greater because of the ability of the government and the Patriot Act in particular to gain access to reporter files. If it's federal, then obviously the Shield Law doesn't protect you anyway. So what people are doing increasingly is taking material off of their hard drives and loading them on the cloud. They're also encrypting smartphones so that people can't seize material in that way. So there are different techniques that people are using, but you can be compelled to produce certain information if either you are the subject of the investigation as a reporter or if there is no other source of information that authorities can get. They do have to make that case before a judge, though. The legal posture that we're in right now is a complicated one because you have the interplay of constitutional protections against compelling journalists to produce information. You have new concerns about national security that give the government a right, an interest and a right to collect that information. How that balances out is a difficult thing for reporters on the ground to sort. But one of the things that reporters can do is to assume that what they're doing is protected activity. It's protected by the First Amendment with respect to the right of freedom of the press. It's protected under the Fourth Amendment with respect to unreasonable searches and seizures. It also is protected under the Fifth Amendment against self-incrimination. So, you know, we're journalists, we're not supposed to sit there and render legal opinions about whether we have to produce or not. But in order to guard against that eventuality, obviously you can sort your materials, separate them from the main, hard drive on your computers, and increasingly people are doing that, and also protecting them on cell phones. With respect to the layers of passwords, yeah, you can be compelled to produce your password unless there's a Fifth Amendment issue, and that's when you have to bring the lawyers in to make that determination. But the authorities also have to make a substantial showing. If it's a traditional case of need for information in a criminal investigation, we're not talking about an issue of national security. If it's the garden variety criminal investigation, then for the authorities to even come into the newsroom to collect information, they have to have a subpoena, not just a search warrant. A search warrant is much broader, and it's there's a threshold that's much lower in terms of what has to be produced, and without getting into all the legal niceties of probable cause, and if there's a likelihood that they might find something, which creates that whole risk of a sort of a fishing expedition, they have to make a substantial showing for a judge to issue a subpoena in order to collect specific information. But of course, if that information is hidden away, then the password is not going to be of much use. So it's a very practical concern. Ultimately, a reporter can be compelled to produce information, again, if it is subject to a subpoena and it is shown before a judge to be significant in proving a case. And always, if the reporter is herself the target of the investigation, then there is no defense. With respect to the privacy of digital information, particularly when it comes to your phones, we're into a very troubling area with respect to access of authorities. And often this comes up with reporters who are traveling from one airport to another, particularly when they're coming from overseas. You go through security, and the authorities can take your cell phone and look at it. And if information is readily available, they can take a look at the information there. So it's a troubling consideration in that regard. With respect to protected information, they have to show some cause in order to force you to produce your password and open up the files. So at least there's that degree of protection. But increasingly what is happening is people are handing over their cell phones, and once the authorities have the cell phones, they can look at anything that's in it. And that's not that different from the typical Fourth Amendment considerations, where you have a reason to suspect something, and you have the access to the information. It's kind of like the ability of the police to search your car. If they believe there's something in there and you're there, they certainly can search for weapons to make sure that they're going to be safe. If they find anything else, then that can be used against you. So the same kind of principles will apply here. The difference is that you have the technological means to lock everything up. And increasingly, people are using Android technology and the coding systems that can create layers of protection for your data. But they can get your call lists, they can get your history, they can get any data that you've collected, and obviously that's fair game once they have access.